I would have felt as if I did not have a discourse or a recourse, I beg your pardon, to deal with many of the things I would have heard. I am very pleased, therefore, that we're here at this time to ensure that there is recourse for persons who have been victimized over many years. Sexual harassment, we believe, has been normalized to some degree in this society. And I am here with Ms. Gordon, who really is a subject matter expert. So I want to not delay any further, but to hand over to her.
Good afternoon, Chairman of this Honorable Committee, members of the committee, and colleagues and persons who will be presenting today.
Ms. Gordon, you may remove your mask to make your presentation.
Guided, Chairman. Good afternoon, Chairman of this committee, members, and those present this afternoon. Casey Carr and myself, Ida Gordon, are here to present the Ministry's submission on the anti-sexual harassment legislation. There should be two documents before this committee. There is a formal submission, several pages long, and you would have before you as well a visual PowerPoint that would just take you through the succinct areas of the submission. From time to time, I may refer to the formal submission where it is best to read the Ministry's formal remarks. I direct your attention now to the submission and to the screen. The first slide. We're having a little technical challenge. I seem to be having a technical challenge. Okay. Now, in terms of the Ministry's portfolio, when we think of the Sexual Harassment Act and the national policy prescriptions that will come from the work of this committee when it is finally approved, Minister, we see the Ministry of Education, Youth and Information playing a very important role in terms of its implementation. And we've highlighted some of these areas in terms of leadership for our sector in the making of education laws and policies that are consistent with the approved sexual harassment, anti-sexual harassment legislation, in terms of our supervision of the child protection system, in terms of the environments, that is safe and welcoming institutions and codes of conduct to govern those institutions, in terms of prevention, looking at curriculum, teaching and learning, co-curricular activities, looking at, in terms of our portfolio for information, media literacy, broadcasting codes, public education. Honorable Chairman, in looking at responding to the scourge of sexual harassment, the whole matter of reporting through the Children's Registry, the whole matter of counseling and support through our various institutions, and the whole matter of referral structures that we also have in the area for children and students. And we're also key in terms of building partnerships and participatory mechanisms in terms of teachers associations, parents associations, student leadership associations, and in terms of our youth leadership and participation. So the Ministry of Education, Youth and Information fully endorses this, this proposal that is before the committee, and really looks forward to the partnership in all of these areas in which we can ensure that this act, the bill that we have before us and the policy reaches its outcome and intended beneficiaries. Sexual harassment has been recognized in international human rights discourse as a form of discrimination based on sex, as well as a form of sexual violence. And we believe that there is a need to address concerns about sexual harassment in numerous areas of national life, and that an inconsistent treatment of the subject by the law is not recommended. And so we really welcome the leadership that has been shown by the ministry in terms of putting together a definition and a mechanism that persons who have been aggrieved by this behavior can seek redress. A rights-based approach requires that national laws recognize sexual harassment as a form of discrimination and gender-based violence. And we believe that the legislative outcomes focused on enhancing measures for the identification, protection, prevention, and response to sexual harassment requires this consistent approach, and an approach that sees it as a continuum of behavior in terms of gender-based violence and in terms of against discrimination. We adopt the view that has been held by the Ontario Human Rights Commission that if left unchecked, and I'm quoting, if left unchecked, sexual harassment in the school setting, and we could substitute here for the other institutional settings that fall under the ministry's portfolio, has the potential to escalate to violent behavior, including sexual assault, if it is not checked. It creates this toxic environment in which persons' rights can be infringed. In terms of the policy, I'm sure the Honorable Committee and Chairman that you would have been aware of all the various international instruments that would have gone into informing this policy, such as the Convention to End Discrimination Against Women. But in terms of our perspective at the Ministry of Education, Youth and Information, we just wish to highlight a few of those norms which govern our operations. And these include the UNESCO Convention Against Discrimination in Education and Convention on the Rights of the Child. The formal document that we have submitted has the appropriate references and citations of some of these relevant provisions. I won't detain the committee on those matters. We also have in our framework the Education for All framework and the Sustainable Development Goals. Essentially, as I said, continuing the theme of human rights and gender and non-discrimination. For us within education, youth and information, the essential elements is that persons must have access to education, and that discrimination or different treatment or actions of this nature that impede someone accessing their right to education is of grave concern for us, in addition to the fact that this behavior affects persons' human dignity. We also are aware that there are pertinent legislation that works with the introduction. It is consistent, the policy and the bill that is being consistent is aligned and is consistent with and will strengthen existing provisions, including constitutional provisions, the equality provisions, the special rights that are there for children, legislation such as the Public Defender Interim Act, the Child Care and Protection Act, the Education Act, provisions that are already contained in the criminal law, are all supportive of the moves that we are making and considering here today. Why then we say, do we need sexual harassment, anti-sexual harassment bill or policy? And perhaps we could just zero in on some of the main challenges that as a ministry we have faced. Although we have these provisions in the criminal law, although we have provisions in child care and protection legislation, we had significant challenges when we sought to develop a sexual harassment policy for central ministry and for schools, in the sense that we could find no authoritative definition of what was sexual harassment. In fact, the staff orders did not at the time treat with it. And we wanted something that could be rolled out and be acceptable to our diverse groups. And there were, at the time, there were different approaches that were being taken in terms of the definition, different ways in which the standard of proof was being debated. And it is therefore something that we had as a difficulty in rolling out a policy for our various constituents. So we also, when we obtained the portfolio for children and youth, wanted to look at how do you translate an anti-sexual harassment position with a child's rights perspective. So those, from our perspective, were some of the challenges that we were experiencing, and which is why we welcome the leadership that has been taken in terms of these measures to curtail this scourge. Now, in terms of gender-based school violence, which is what that acronym stands for, and you can take that for also in institutional settings, you can see that it can occur in 3 various dimensions. We have incidents between staff, we have incidents between students close in age, their peers, and students who are not close in age, and we have incidents that may be between staff and students. And you can also see that this would be in the case of child protection settings. But I pause here because there is, an example or an illustration that Ms. Carr can bring to you in terms of incidents that can occur with persons seeking social services and the staff of a public sector entity who is responsible to give those services. And I will allow her to speak on the illustration.
Thank you. So specific to, thank you. We had concerns that persons who come to seek services from the institutions established could be susceptible to sexual harassment, and those persons who are offering the service could also be susceptible. We've had examples of this, and like Ms. Gordon had said, we had no reference point. We didn't know how to treat with it, because in the staff orders, it says very generally unprofessional behaviors or something to that regard, but nothing specific to sexual harassment. Specific to my area, persons who come might also already be in vulnerable situations when they come for services like counseling services, and they too would be even more susceptible because they're already facing challenges, and they would not at this point be in a position of power. The power would be on the service provider, and so that is of concern as well.
Thank you, Ms. Carr. What we had a challenge in terms of when we first received the bill and we were reviewing some of the, if I could just bring up the bill, when we were reviewing the specific provisions of the bill, and we were not initiated in the definition of sexual harassment, this concept of unwelcomeness. And just to refresh the committee, sexual harassment under the bill is defined to mean the making of any unwelcome sexual advance towards a person by another person, which A, is reasonably regarded as offensive or humiliating by the person towards whom the sexual advance is made, or has the effect of interfering unreasonably with the work, performance of the person to whom the sexual advance is made, or creating an intimidating, offensive, or hostile work environment. And of course, there are other definitions for sexual advance and to sexual harass. And for us, coming from a child or youth perspective, we had some initial difficulty with this concept of unwelcomeness, where some of our constituents would be minors, and we wondered to what extent one could ever, a person who could not give consent to sex, how could they ever be said to welcome, conduct? And we debated this. But we did some research. We understand now that unwelcomeness is a core concept of sexual harassment legislation, and it has been interpreted by the various tribunals or bodies that have to hear the cases and develop jurisprudence. It has been interpreted appropriately to be treated with for children. And one example we gave in our formal documentation to the committee was the Office for Civil Rights, and they have the responsibility to administer the Education Amendment 1972 in the United States of America in terms of federal funding to institutions. And they don't give that funding if there are issues of civil rights abuses, including this whole matter of sex discrimination. And in their guidance on students, sexual harassment by students, by school employees, students, or third parties, it was said, and I quote, "If elementary students are involved, welcomeness will not be an issue. OCR, which is the Office for Civil Rights, will never view sexual conduct between an adult school employee and an elementary school student as consensual. In cases involving secondary students, there will be a strong presumption that sexual conduct between an adult school employee and a student is not consensual. In cases involving older secondary students, subject to the presumption, the OCR will consider a number of factors in determining whether a school employee's sexual advances or other sexual conduct could be considered welcome." And for another perspective, we also looked at case law coming out of the Ontario Human Rights Commission. And they said in their guidance, the reference to comment or conduct that is known or ought reasonably to be known to be unwelcome establishes a subjective and objective test for harassment. The subjective part is a harasser's own knowledge of how his or her behavior is being received. The objective component considers from the point of view of a reasonable third party how such behavior would generally be received. Determining the point of view of a reasonable third party must take into account the perspective of the person who is harassed. In other words, the Human Rights Tribunal of Ontario can conclude on the basis of the evidence before it that an individual knew or should have known that his or her actions were unwelcome. And they have case law of a young age complainant. And they said the young age of the complainant made the respondent's behavior more vexatious and weighed heavily against the possibility that the respondent did not know or could not reasonably be expected to know his comments and conduct were not unwelcome. So we have confidence that in terms of the evidence that would come before a tribunal when it was considering the conduct, that we will develop jurisprudence to indicate how this concept of unwelcomeness will be dealt with for children who may complain to the tribunal. In terms of comprehensive approach to sexual harassment in other countries, we have included quite a bit of information in the submission on the various approaches that other territories use for sex harassment. And we did this to make the point that there isn't just one legislative intervention. And in fact, if you have a layered intervention, that is really what you hope in terms of addressing all aspects of the infringement, because you want to enable persons who feel harassed, you want to allow them the options for what remedy they wish to pursue. And some of the remedies may not be, for example, instituting a constitutional claim for discrimination on the grounds of sex, or necessarily going through a criminal prosecution. Those may not offer the redress that the person who has been harassed may wish to pursue. So as long as you have harmony in terms of harmonization, in terms of the definition of what constitutes a sexual harassment, and you're taking the perspective from a human rights and an anti-discrimination perspective, then we believe that a comprehensive layered approach through the law is quite appropriate. And so we have given examples of the UK. We had a look at Canada. We also looked at some of our Caribbean jurisdictions, and also we had a look at South Africa, and all of that information is captured in your documentation. What we have seen in the field of education specifically is that once you have this authoritative definition in the law, then schools are able then to put forward policies which draw on the law, and we can then give guidance to schools and institutions with the authoritative weight of whether it is the criminal legislation that we are citing, or we are citing in terms of the redress that is available in legislation such as this being contemplated. We wanted to end our presentation just by noting that there are some complementary measures that the ministry is pursuing. On the education, as I mentioned, we had the draft sexual harassment policy, which stalled because of our lack of consensus on this authoritative definition. But we are also pursuing gender-based or gender-sensitive health and family life curriculum. Our national safe school policy is being reviewed to ensure that there is sufficient coverage for gender-based violence in schools. We are looking at, in terms of our bring your own device policy, there is a model acceptable use policy that is attached, which speaks to appropriate conduct in the use of digital devices. We are also pursuing legislation for the professional regulation of teachers, which will have professional standards for the teachers that interact with students. Under our youth portfolio, we have our national youth policy, and of course the National Plan of Action for an Integrated Response to Children and Violence. In terms of information, there is a media campaign for digital literacy that is being put on by the Broadcasting Commission, and the Broadcasting Commission also has a children's code for programming. So these would be all the initiatives that we have put in place and which can be strengthened by legislation such as this and by a comprehensive policy response. Chairman, we only have some specific recommendations to be made and for the consideration of this committee. They are set out in our response. I'll give you the page reference in a moment. It's at the end at page 13. And what we're asking in terms of these specific recommendations is a consideration of this committee that there should be a definition for child in the legislation consistent with the definition that is contained in the Child Care and Protection Act. We're also seeking if consideration of whether hostile environment, which is used in a definition for sexual harassment, whether this honorable committee would consider extending that hostile environment harassment to institutions as appropriate. And we also wanted the committee to consider in terms of the constitution of the tribunal, we wanted to raise for the committee's consideration whether or not that tribunal should have someone who represents children or youth, particularly if there are issues that would come up relating to children and the sensitivities that would entail. In terms of the making of a complaint, I apologize, Chairman, I was not given the sectional, the clause references, because there is our formal document does give the clause references, but for the purposes of the record, clause 2 of the bill in relation to interpretation, the recommendation is for the definition of child to be included, also for the definition sexual harassment, for hostile environment harassment to be extended to institutional settings, for clause 11 of the bill in terms of establishment and constitution of the tribunal, for it to include a person with representation for children and youth. For clause 25 of the bill, in terms of making of a complaint, we are asking the committee if they could consider having someone, a representative of the child make that complaint. If we look at the public defender and the children's advocate legislation, it speaks to the child making a complaint through the parent, guardian, next friend, or person in loco parentis, so that the child themselves don't have to be the complainant. And we also, in relation to Clause 25, are putting before the committee that the limitation period is too short in cases where children have up to 6 years to file a civil claim in relation to a physical accident that happens in a school. We believe that if there is something egregious as this, that children should also be afforded 6 years, the policy of the law being that that is sufficient time for persons' memories and evidence, and there is no prejudice to the defense of the case. So if the law of if the policy of law already has 6 years for civil actions, there should be no difficulty in terms of the policy of the law extending for these situations. Even so, when you have children who may be emotionally and mentally impacted by the conduct which they have experienced. And we are also, in terms of the directions that are to be given by the officers as part of the enforcement procedures, the directions of the officers of the ministry, we are wondering whether or not there should be some indication of what type or some guidance that is given to the officers in terms of what is the directions that they can give. Is there any statutory guidance as to what directions can be given to someone? Owing that if you breach the directions, it's a criminal offense. So we wondered whether or not there could be some statutory considerations that would guide those officers in making their directions. And in terms of Clause 30 of the bill, we wanted to put before the committee consideration of the standard of proof that would be utilized in the proceedings, and we wish to put before the committee the civil standard. Madam Chairperson, if there is anything that we can assist the committee in, we stand ready to do so at this point. And we thank you for the opportunity for inviting the Minister of Education, Youth and Information to make this presentation to this honorable committee. Thank you.
Thank you. I thank you both for your presentation. And I will now open the floor to members who may wish to ask questions. But I just want to indicate, before I take the questions, that Mrs. Coburn Robinson, who is present with us from the Bureau of Gender Affairs, she has with her a ribbon. See, I'm wearing a ribbon, celebrating our men. And we will have the orderly pin members here, both men and women, in celebration of our men. As Senator Longmore, I know you're very pleased about this fact that we are celebrating our men today. Very good. So, orderly, please make sure everyone wears a white ribbon. All right, so I thank Ms. Gordon and Ms. Carr, and I now will start taking comments or questions from our members here. Senator Gale, you want to go first? Thank you. It's your day.
Chair, you always ask the Gale to open the batting, so I will not decline. Thanks for, well, it's a very voluminous presentation in terms of the narrative, and good reading also in terms of the research that was done. But I want to take you to your recommendations on page 13 and start with your reference regarding Clause 2, with specific reference to consider introducing a definition for person in charge. And you said we recognize that this may be the terminology commonly used, but the person in charge is often, and I suspect you meant employer instead of employee there. The person in charge is often, it has employee, and I suspect they meant employer.
No, what they're saying is that the person who's in charge is an employee, but that person is employed to someone else.
Oh, okay.
So, right.
Okay. So the reference to person in charge would be in clause 4(2). Every person in charge of an institution. So, do you have a type of definition that you would want to represent in that regard? And my second question, or seeking clarity, would be in relation to clause 25, where you're suggesting here that, and this is particularly now for the institution or the school, where the child, the complaint can be made with someone outside of the child, because the situation where the child might not be able to make the complaint. And so you want an insertion in the legislation to suggest that someone other than the child, the parent or the guardian, or another person or a teacher can make the complaint. That there is no reference in the legislation to indicate that. So those are my two areas, Chair, where I would be seeking some level of clarity.
I invite your response.
Thank you, Chairman. Thank you, Member. I apologize, I had skipped over the matter of the person in charge. What we had a concern for is we were recommending that a definition be included in clause 2 for the term person in charge. And this was because that person is described in the legislation. That person is a duty bearer in the legislation. And in our sector, usually the person in charge would be a principal, and that person of an institution or a director of an institution. And that person is often an employee. And in the case of educational institutions, the proprietor or the board of management is really the policy-making organ. And the principal is carrying out the edicts of that proprietor. The principal or the director is responsible for day-to-day administration, whereas you would have the owner or proprietor or the board of management being responsible, really being the person with power. And we wondered whether there could be a definition included in Section 2 for person in charge, to include not just the person who has the day-to-day administration, but so you don't want to exclude that person, but you want to include the person with the power, which is perhaps a proprietor, owner, or board of management, or governing board, or terminology along that line, so that you could hold accountable the persons who had the authority to actually have these policies in place. So that was the proposal. In terms of the making of the complaint, the language that we were using in the recommendation was taken from, I believe, the schedule of the Public Defender's Interim Act, and it's that the complaint can be made in a representative capacity, so that a parent, guardian, next friend, and person in loco parentis could make the application on behalf of the child before the tribunal. When we read the act, we understood that you wanted to extend it to educational institutions, but in terms of a child perspective, it could have, looking at it from a child law perspective, we wanted to see some specific provisions under the legislation that would make it accessible by children. And one of the ways to make the tribunal accessible to children is to allow for representative claims to be made. So that would, I'm not sure if I've addressed the members' concerns.
Yes, you have. Thanks.
Thank you, Senator Gale. Okay, Senator Motley.
I think also that the question of the 6 years, I have a concern about the length of time which has been proposed by different persons who have made submissions. And I wouldn't mind hearing exactly an expansion on the thinking that has gone into the ministry recommending 6 years. And in particular because it involves a child. So the person who is ill-informed, unadvised might say, but a child's memory is more fleeting than an adult's memory. And I thought that it would be helpful to all of us who are listening for you to give us a perspective that made you came to that recommendation of 6 years.
Thank you, Member. The recommendation was informed by the policy that goes behind a statute of limitations legislation. So it's a balancing both of the complainant as well as the person who is complained against. And we used it as a standard that was already established in law for some period of time, that in terms of actions such as tort or civil actions or the adjudication of rights that arose out of either contract or tort, that in those circumstances there would be a limitation period of 6 years as a way of balancing the ability for you to mount your defense as well as time that it would take for the child to be able to bring the complaint. We understand that in some jurisdictions it's much longer. Ontario introduced some legislation and it changed the reporting period. It's the particular legislation or law is cited in the submission. We simply used, as I said, an established legal standard that showed the balance of the policy, both in terms of bringing your claim and in terms of the ability to defend the particular incident. Because this was a civil tribunal. It was not a criminal jurisdiction. It was a civil scenario, and therefore we aligned it with that standard. Thank you.
But also the levels of discomfiture.
Thank you. Thank you. Would you like to, Senator, MP Morrison? Please go ahead.
Thank you very much, Chairman. This presentation, Chairman, it finds favor with me. I especially like that a lot of research went into this. We have a lot of context to work with. I'm particularly impressed with the very first slide. And that's something that I would recommend be in circulation, especially for educational institutions. And that aspect of it that speaks about public education, and it speaks about prevention. So we aren't just here discussing this issue because we have been discussing this issue for years, but in your presentation you have taken it a step further to suggest how educational institutions can treat with this issue. The response given to Senator Gale, I am impressed with how you have handled it. I'm looking at that particular section 6 regarding the person in charge. And I want to suggest to this committee that because we are dealing with children, we invest much time in looking at the legislation to ensure that we protect our children. Very often we have heard about sexual harassment in our schools. So we want to ensure that we invest the time so that our children, they have avenues through which they can speak. And even though I'm guided by what Senator Motley mentioned about the 6 years and the attention or that the memory being fleeting, we fully consider children, we consider the psychological aspect of it. I'm sure Senator Longmore feels very strongly about that. And we don't just run away with this or we want to get the legislation out there, but we really ensure that the reality, the ugly reality that sometimes will play out in our schools and institutions that are responsible for children's welfare, that the bill clearly speaks to how we are going to protect our children. But excellent presentation, ladies.
Thank you, MP Robinson. Let me have your response from the Minister of Education. And yes, please go ahead.
Thank you, Madam Chairman. I would like to share this moment with I would like to share, ask Ms. Carr to share on the particular aspect of the limitation period, the issue of the limitation period, what informed the decision of the ministry, if we could just add to that comment, if I'm permitted.
Right, just to say that depending on the age and stage of that particular child, the child might not even have recognized at the time, have not been empowered with the information to even detect that she would have been sexually harassed. And so over time, also when you're in the context, when you remain in the context, meaning that the person with the authority is still in the presence of that child might feel very intimidated and not want to come forward. Given a longer period where the child is more mature and feel more empowered, he might want to come forward.
Thank you very much for that explanation. I think it's important, as I said, that the committee members appreciate the thinking behind your recommendation. And may I also add my commendations. It was a very thorough presentation, which I'm sure we will find much use for outside of this committee.
Thank you, Member.
I just wish to add that in terms of our first slide was adapted from PAHO's instrument on dealing with gender-based violence in schools. So there's a PAHO instrument, and we used their layout to inform that diagram.
Thank you, MP Davis, and then I'll take Senator Longmore and Senator Johnson-Smith after.
This is not MP Davis, but that's fine. Senator Morris here. Madam Chair, thank you. I just want to add my vote of commendation for that comprehensive presentation. I find that it was very much tailored to include how we can safeguard our children and youth. And I want to point out an area that I think was commendable and very important to mention. It was the modification of Section 11, Clause 11, 1C, to include members in the other members category that have expertise in child relations and youth relations, and I think that's important for us to include in this piece of legislation, along with other personnel who will specifically cater to mental health issues. And so I believe that it's important for us to revisit this area and include those recommendations. But in short, very, very, very wonderful presentation.
Thank you, Senator. We'll now take Senator Longmore.
Is it this one? Yeah. Thank you, Chair. Again, I congratulate your presentation. Very, very informative and thoughtful. Two quick points regarding your recommendation for Clause 2 for the extension of hostile environment to include institutional settings. I think that is definitely something for us to consider, considering the very vulnerable nature of some of our institutional settings to the young persons who may engage them. So I think that is definitely a recommendation for us to definitely incorporate. Secondly, with respect to the statute of limitations, etc., just to underscore that, and it came out with respect to your response, but it is very hard to quantify the damage that has been done, especially to a child. More and more we're recognizing what is now the buzzword in trauma and traumatic experiences, which is ACEs, the adverse childhood experiences. And we are recognized, it is long recognized that the ACEs have contributed significantly to subsequent mental health issues, post-traumatic stress disorder, depression, substance use, personality disorders. But it is now even proven that it is now affecting the promulgation of chronic lifestyle illnesses and immune-based illnesses, so autoimmune diseases, even cancers. And so these early traumatic experiences, it is very hard to put a limitation as to the extent of potential damage, but we also have to strike the balance where we don't become overzealous with respect to what can be claimed and brought in terms of a time frame. So I just wanted to bring that to our awareness that what is clearly laid out now, I think we are kind of unanimous in the fact that it has to change. But I also want to bring the unique situation as to what happens when the offender is also a child. And subsequently, the victim does not realize in the moment, etc., and later on, that repressed memory comes back. So definitely for us to consider in those contexts.
Thank you. Would you wish to comment?
Only to endorse the comments of the member.
Thank you. Senator Johnson-Smith?
Thank you, Minister, and allow me to join the words of commendation that have been issued to the Ministry of Education team. I think we've all learned a lot and certainly have substantive matters to consider more deeply when we reach to the appropriate stage. I was actually wondering about the complementary activities mentioned towards the end of your presentation. The adjustments to the health and family life curriculum, the looking at the bullying policy, etc. Are these activities awaiting passage of this bill for consensus on what the definition is, or are you proceeding recognizing that that the principle of harassment and the principle in terms of teaching children now how to deal with each other, what boys and girls should expect from each other in a school or social setting, and what is appropriate behavior and what is not, is that already underway, or is that awaiting? As I recall that earlier you said that your policy had been stalled because of lack of consensus, and I'm wondering if with all the material that you have shared, which shows certainly a cross-cutting understanding of the principles that would underpin conduct, I wondered if you could share some with us about where you are in that process.
Thank you, Honourable Senator. In terms of just for clarification, the sexual harassment policy that we were developing for the ministry and the schools, because we were trying to integrate disciplinary procedures and that sort of grievance procedures, and we were getting very technical. We began to stall because, as I said, we didn't have the authority of, say, the staff orders to bolster what we were trying to do. But generally now, when we speak about the safe school policy, that is being revised now with the assistance of partners. And we are using the frameworks that have evolved around school-based gender-based school violence. And so we are using those principles in terms of the bullying and in terms of appropriate conduct and in terms of appropriate acceptable user policies and procedures for the use of IT. And those things can go ahead based on general principles. The reason why the earlier policy had stalled is because we were getting into very detailed procedural matters, and both teachers and civil servants have a statutory framework that already exists for their discipline, and it was as if we were introducing something additional to, even though we were seeking to say, no, it's actually just an expression of existing principles. It seemed to have been additional to because it wasn't mentioned in the staff orders. So that's a distinction. In terms of the safe school policy, now we can proceed on broad general principles that are accepted based on the human rights instruments that already exist and our responsibilities under the Convention on the Rights of the Child. In terms of the aspects as to the revision of the curricula for health and family life, I would have to get further information from the personnel in the ministry who have that under their jurisdiction. I do know that they do have in there a part about knowing about yourself and those sorts of, and how you interact with others. There is material, but as to the extent to which we are reviewing it based on gender policy, I will provide that later to the committee. Thank you, Chairman.
Yes, thank you, Chairman. So whereas the recommendation does speak specifically to HFLE as the National Parenting Support Commission and a member of the Gender Advisory Council, then we have, based on our own policy, remit to ensure that we empower prospective parent, which in this case would be persons in high schools and even lower. And so I have been, and the Commission in general, have already started the process of education regarding sexual harassment and gender-based violence. In fact, I ensured that my own staff did the sexual harassment or anti-sexual harassment training that was organized by the Ministry of Bureau and the Ministry of Gender Entertainment.
The Bureau of Gender Affairs.
The Bureau of Gender Affairs. Thank you. I know it slipped to me. Thank you. The Bureau of Gender Affairs. So all of my staff members participated in that, and we have since then even sought additional information on sexual harassment. So we really have been doing training sessions. I think it is very critical that we not wait until this bill is passed, but we start the empowerment from now in language that everybody can understand. Okay?
Thank you. Thank you. Senator Fraser-Binns? Were you finished with your? Okay, thank you. Yeah.
Thank you, Minister. Let me join my colleagues in congratulating you on a very thorough presentation. I want you to provide some guidance for me on three things. First, it has to do with the statute of limitation, and I heard the answer that both yourself and Ms. Carr gave in terms of the statute of limitation. But bearing in mind the age, the very young age of our children, I wondered whether there was any thought as to a further period for statute of limitation, and also whether there are any countries in your research that have a longer period specific for sexual harassment. So that's the first one. Secondly, I am very pleased because I think it was MP Morrison who raised the issue of children. No, it was Sapphire, sorry, Dr. Longmore, who raised the issue of 2 children being victim and offender. And it's something that occupied my mind until I read through your presentation, and I'm very happy you raised it because you have provided guidance for us in terms of how you treat with that situation, coming from the Ontario situation. So I'm very happy about that. The other thing for which I need some guidance has to do with the definition of a person in charge. Because in your presentation, which we accept, the Board of Management, no, the school board, yes, Board of Management has the responsibility for the administration of the school. But that is for public schools pursuant to the Education Act. How do you see that working in a situation with private schools where we do not have established Board of Management? What you have is maybe a school, a church, or you have 2 friends come together and set up a school. How, just help me to work through my mind, how would you have the person in charge there and who would do that? And yes, those are the 3 things, Minister. Thank you.
Thank you. Go ahead, Ms. Gordon.
Thank you, Chairman. May we be permitted to some time to just study the 2 recommendations put forward, and we would provide what information we can to the committee. If we are given a period of time within which to just do a little more research, because these are concerns, and we can provide more assistance to the committee.
Sure. Mm-hmm. Okay, so I really want to thank you for your presentation, excellent presentation. Thank both of you. And, oh, I'm sorry, Mr. Bailey, is that you?
Good afternoon, Chair.
Please go ahead.
Thank you, Chair. Before the ministry wraps up its presentation, There are a couple of things that I think perhaps might assist us. And I join firstly with congratulating them on an excellent presentation. The question of the person in charge, the rationale for the choice of those words was to make it as wide as possible. Who is in charge is going to be typically a finding of fact before the tribunal. And since titles and circumstances will vary, I think Senator Binns just referred to that, this was seen as more general words that can be pinned down depending on the particular circumstances. We may run the risk that in having to define this further, that you may have to have a barrage, a long list of words relating to who's heading an institution, what kind of institution, and so on. So I simply put that one out there as a caution. In relation to the comments made in relation about unwelcomeness and the commendable sanguineness of my colleague, Ms. Gordon, about the jurisprudence that may or may not develop. What this has, in relation to children, by the way, what this has actually indicated as a very good point is the nexus between what is sexual harassment for the purposes of this bill and what is a criminal activity with children for the purposes of the Child Care and Protection Act, where you have a staff making unwelcome advances to a child. That is prima facie, I believe, actually a criminal act. So it does highlight a very serious problem, and for that and among other reasons, I certainly commend them raising this, and also the need for the next friend to be able to make that complaint and have the children. But it also does highlight the problem that the committee faces and the country faces, because we're really talking where this is skirting very close, if not having crossed the line, where an adult is interfering with a child. So that is something I'm not sure that I don't know if this bill can address that as such, but which carries me to my third point. In relation to the initiatives of the ministry to develop guidance and codes and the like. In a previous meeting of this committee, some concerns were raised in relation to the needs of the tourism sector. And one of the things I believe that we had discussed at that meeting is the possibility, for example, of including provisions in this bill that would enable the promulgation of industry or sector-specific codes. And these codes could be things that could be developed in the particular sector or ministry or industry itself, which would have to exceed the floor of this bill. This bill sets out basic standards and the basic policy, but those codes could exceed that and be specifically oriented towards a particular sector or industry or whatever. And these could be given some force of law, recognition in law, by being promulgated once they're settled by the minister. And something like this may be something that will be useful in this context in relation to whatever is being developed by the ministry, so that there will be an understanding in their particular sector, in their institutions, in their schools, that these are absolute standard. This is the standard that you need to apply where you're talking about sexual harassment. They can get even more stringent if they require, but at least those are the particular levels of behavior that needs to be addressed, and also that the responsibility for dealing with reports of interference, harassment, whatever, is taken very seriously and is prosecuted rigorously.
Thank you, Mr. Bailey. Ms. Gardner, you wanted to make a comment?
Just the final point. Thank you very much, Mr. Bailey. The point we had raised in the brief, the country situation of Canada. What we've seen in some of these jurisdictions is that sexual harassment or gender-based violence is dealt with in many different areas of the law. So you will have perhaps some kind of anti-discrimination or human rights legislation. Then you'd have another layer dealing with labor. You'd have another layer dealing with criminal law. You may have specific legislation for the schools. In Canada, they have their criminal code in terms of how they define a sexual assault. There are quite a few offenses that can exist for children in relation where the child is a victim. And there is also legislation under their Education Act that speaks to safeguarding. And yet the Office of Human Rights also has this jurisdiction to deal with complaints of discrimination. So you can have a comprehensive approach in your jurisdiction because the literature speaks to the victim. I don't want to use a victim, that's not the right terminology, but the person who has, the complainant, who should have options for adjudicating their complaint and also remedies. And if you choose only a criminal response, then those remedies that are afforded through that avenue may not be what the complainant wishes to access for their particular situation. So it's not an either or. You can have more than different options in dealing with gender-based violence, and in this specific type of violence being harassment. You can have a criminal response, you can have a civil response, you can have labor response, education response. The key point is there must be harmony in terms of how you're going about defining the sexual harassment. And again, in Canada, they had to do legislation that went over all of the various acts just to harmonize the way in which we treated with definitions and periods, limitation periods and that such things. So yes, thank you very much for the time you have afforded us. Very generous in terms of the time you have afforded us this afternoon, and thank you.
Thank you for your presentation. So now we will move to the next presentation. Normally at committee we are served coffee and tea and so on, but we can't be served in the room. You can only have water, but if you wish to have coffee or tea, you can walk down the hall and have a sip and come back in. Okay, so we will quickly take a presentation from the Rent Assessment Board, and the presentation will be made by Mrs. Shanice Williams-Headlam, and she's Director, Rent Services Unit in the Ministry of Economic Growth and Job Creation. So, Mrs. Headlam, thank you so much. Please go ahead with your presentation.
Thank you very much, Chair. Thank you very much for having me here. I am representing Mrs. Doreen Prendergast, who was originally invited to represent the Rent Assessment Board. So the Rent Assessment Board made a number of some contribution to the Sexual Harassment Act, which is now a bill, but so as it relates to Section 4, in addition to a policy statement, every employer should be charged with the responsibility to conduct training sessions for new and existing staff regarding harassment, sexual harassment. These training sessions should include role play, scenarios, and examinations. This will allow employees to identify appropriate behaviors at work and also inappropriate behaviors that are identified in the training sessions can be rectified there. And we recognize that training in the workplace is essential as it strengthens the workplace culture. Training can support and help strengthen the organization by communicating its values and goals and policies in creative and meaningful ways that motivate individuals to act ethically while protecting the organization and its reputation. Also, training can increase awareness of acceptable and unacceptable behavior. Training is one of the most effective and efficient ways to raise awareness of the different types of unacceptable behavior, from the obvious to the subtle.
and remove uncertainty about what is and what isn't appropriate and lawful behavior. Through realistic examples and other relevant content, training can clarify the gray areas and demonstrate how unwelcome conduct goes unchecked can become harassment. It also encourages reporting. And many incidents of harassment and discrimination go unreported. So within the training sessions, when the training sessions are conducted, persons will know that they have a means of redress if it occurs. As it relates to Section 9, the board thought it was best to include these recommendations. So the following can be included in Section 9, which speaks about accommodation. Landlords and tenants should not make sexual advances by making suggestions, remarks, innuendos, unwanted physical contact, gestures, verbal or nonverbal communication. Sexual favors should not be suggested or requested in lieu of rent, bills, or repairs to the property. And I can give an example. I can recall an incident where a landlord and a tenant had an arrangement to forego the rent that was owed by the tenant. The landlord and tenant agreed that the tenant would provide sexual favors, and after those were provided, the landlord still went ahead and sued the tenant at court for the rent that was owed. 3, landlords should not utilize technological instruments such as cameras to spy on their tenants or invade their privacy. And I have another example of something similar that occurred at my office. So that is a bulb there with a camera at the center of the bulb. And I had a client who came to my office and she was mostly stressed. And she said that her light switch, her bulb was not working in her room, and she asked her landlord if he could, or I think the landlord just came in and said, all right, I'm going to fix this bulb. And he brought that bulb that I just showed you with him. And he placed it over her bed, and she was there for a while, and she didn't really pay the bulb any mind. But after trying to turn the bulb on, she realized that something was amiss with the bulb. It was not working. And she took it down and realized that there was a 360-degree camera in the center of the bulb, and the landlord had used a marker to disguise the bulb, a black marker to disguise the camera. And she brought it to our attention, and she further reported it to the police. Now, 4, landlords and tenants who become antagonistic if the other party, landlord or tenant, refuses their sexual advance should be guilty of an offense. 5, a prospective landlord should not make it appear to a person seeking tenancy that the offer of that tenancy is contingent on the tenant's acceptance of any sexual advances. As it relates to Section 9, a landlord should not seek or a tenant offer sexual favors for the continuation of a tenancy agreement. A landlord shall not seek to forcefully remove a tenant from the property if they refuse his or her sexual advances. A landlord who may have personal information as it relates to relationship status, financial status, occupation, work status, etc., about a tenant should not use the knowledge that he has to exploit the tenant for sexual favors. Or she. As it relates, continuing on Section 9, landlords who have keys for their tenants' dwellings should not use it as an opportunity to enter the dwelling in pursuit of sexual favors. a landlord should not use a tenant's vulnerability, loss of employment, loss of spouse, loss of financial support, etc., for sexual favors. Special provision should be made for children in residential accommodations for complaints to be made on their behalf. And this is similar to what members from the Ministry of Education had suggested. As it relates to Section 11, the board believes that this could be included. A provision could be included to have psychologists as a part of the tribunal. Sexual harassment affects persons' mental state, and having psychologists on the panel can provide an explanation about the trauma that the victim faces and also getting the appropriate help for that victim. Additionally, an evaluation can be done on the perpetrator to ascertain why they would have done what they did and how to get help for them as well. A psychologist on the panel would create a balance. This balance would be between the law, which the attorneys would provide as was seen as is in the bill, and the mental state of the victim or the perpetrator. In relation to Section 24(2), there are 3 parts, A, B, and C, and I'll read that section for you briefly if you don't have the bill before you. Section 24(2), the Secretary of the Tribunal shall be responsible for keeping records of the proceedings of the Tribunal, keeping in safe custody the documents of the Tribunal, recording statements of witnesses called before the Tribunal. Now the board is proposing, the board wishes to include which may be used as prima facie. In relation to Section 25, under making of complaints, it does not appear to make provision for children who are harassed in residential premises or to allow for children to make complaints. In relation to Section 36, provisions could be made for parties to go straight to the Court of Appeal instead of the Supreme Court. The Tribunal, the Rent Assessment Board is also a quasi-judicial body, and in our Act, the Rent Restriction Act, the parties who are aggrieved by the board's decision, they go straight to the Court of Appeal. So that is the reason for suggesting the Court of Appeal instead of the Supreme Court. The sexual harassment law should also include other institutions, facilities such as sports clubs, churches, gymnasiums, recreational facilities, swimming pools, spas, saunas, entertainment facilities. Another part that was not included in the presentation that you may have is to include in Section 34 that the perpetrator and the victim should receive mandatory counseling sessions separately. Additionally, they should receive restorative justice sessions. Thank you very much.
Thank you, Mrs. Headland. Attorney from the Ministry of Culture, Gender, Entertainment and Sport, Ms. Georgette Grant, wants to make a comment. Then I will take Senator Rodriguez Campbell. Okay, go ahead, Ms. Grant.
Thank you very much, Chair. I want to thank you very much for your presentation, and I have two comments. The first relates to the first point of Section 36, and I notice you qualified it by saying that the Rent Restriction Act or the Rent Assessment Board, I don't remember which one you said, but that your act allows for you to go directly to the Court of Appeal. Be that as it may, though, I think this suggestion is, it's problematic as it relates to this bill, because you don't ordinarily skip the Supreme Court and go straight to the Court of Appeal. And if when the tribunal, the decision of the tribunal is, for all intents and purposes, final, with the exception if it's on a point of law, then you appeal. The hierarchy as it is, as I'm sure you're aware, is to go to the Supreme Court and then the Court of Appeal. And if there is something that is wrong with the decision, certainly on a point of law, you'd go by judicial review, which is something that should go to the Supreme Court. So I think, regardless of what you stated as your basis for the suggestion, I think it's problematic in that case, and I don't know if that's something you'd want to look at. And as it relates to Clause 24, subclause 2, that the add-on suggested, which may be used as prima facie evidence at court, I am a little confused there why that add-on at that particular clause, because the clause suggests how the tribunal is to operate. So if you're going to add, which may be used as prima facie evidence at court, are you suggesting then, what is being suggested here? Is it as it relates to, are you preparing for an appellate stage, or are you saying that this is something that ordinarily should be heard by the courts? I just want some clarity as to what's...
Thank you for that question. So the suggestion was made in the event that they either, whichever party it is, whether the perpetrator or whether the person who is making the complaint or the defendant wishes to take the matter further. That was the suggestion. That is why it was suggested that it could be used as evidence at court.
That satisfies you, Ms. Guy? Go ahead.
Chair, I don't think that the add-on is necessary, and this is just me, because in the event that it gets there, whatever happens at the tribunal will be requested. So that would go without questions. I don't think the add-on, to me, it seems a bit superfluous. I don't think it's a necessary add-on.
Okay, thank you, Ms. Grant. Senator Rodriguez-Campbell.
Thank you, Madam Chair. Thank you for the presentation, for taking the time, for the Rent Assessment Board to take the time to put this together. On page 2, I think it's page 1, in section 4, where you spoke about training sessions, including role play scenarios and examinations. I mean, great suggestions, but how would you respond to, how would you respond to the fact that many small businesses would not be able to afford to set up, training sessions to include scenarios, exams, and role play? Could we look at maybe an entity such as a ministry with responsibility for gender creating videos? Would that suffice what it is that you're trying to do with this suggestion? That's my first question.
Yes, that would suffice, as long as there is training for persons to know the appropriate behaviors at work.
Okay. And secondly, in section 9, where you have listed, I think it's 11 things that could be included in section 9. As written now, I think it's covered, because if we are to add in all of these specific details, the bill becomes very long. But if you read it as written now, I think it would accommodate. I don't know what the persons from the ministry have to say, but I think these things are covered under 9.1 and 9.2. But are you saying that they needed to be listed out as you have suggested them?
Yes, go ahead, respond.
And then...
Ms. Headlam, you wanted Ms. Headlam to respond?
Yes, please.
Go ahead.
Well, it doesn't have to be written exactly how we have it here, but if it is in the section already and it can be merged, then that would be fine too.
Okay, and then section 25 on the second page of your submission. Section 25, on the making of complaints, you have written here, it does not appear to make provisions for children who are arrested in residential premises. But section 8.1 I think speaks specifically to that. It reads, a person who is a member of staff or in a position of authority at an institution shall not sexually harass a person who is a student or a resident or a ward at an institution.
Okay.
So I don't know if there was something else that you are referring to here, but I think it's covered under section 8.1.
Well, I can't speak to that because I would have to look at section 8 is saying no.
Okay.
Okay. Any member want to make a comment in this? Go ahead, Senator Gale.
What are the residents?
I want to go back to clause 9. And I believe for the purposes of these sittings, we could not have gone through this sitting without hearing from the Rent Assessment Board, particularly because of clause 9. So we are very grateful for them being here. Senator Rodriguez made reference to what is contained in clause 9 and what is being detailed here. Being a little more specific, I want to ask the question as the Rent Assessment Board would have gotten complaints of these natures, correct?
Yes.
And so how far-reaching or wide-ranging have there been these types of complaints being put forward to the Rent Assessment Board? That would be my question.
When we have reports of this nature, we usually send the complainant to the police station to make a report because the Rent Assessment Board wouldn't be able to assist the party at that point.
And so what I wanted also to ascertain, Chair, is how often, if there's a scale in terms of percentage in receiving these types of complaints or reports?
Well, as it relates to our records, we do not record. We have no mechanism to record these types of complaints, but we usually send them to the relevant authorities, but we don't record it.
You know if when they are sent to the relevant authorities, they are addressed?
Well, this one was addressed because we had contact with the police, and I think the tenant had taken the matter to court.
Senator Motley.
Chair, Chair, I wanted to thank Ms. Headlong.
Yes, Mrs.
For her presentation. But I wanted to ask her a question in light of a recommendation she made that the sexual harassment law should also include other institutions. And she specified a number of facilities like sports clubs, churches, gyms, and so on. And I wanted to ask her if she didn't think that the fact that the definition of institution also included a place for the use of any facility by members of any organization and such other place or facility as a minister may by order published in the Gazette designate as an institution for the purposes of this act. If you didn't think that rather than expanding the list of definitions, which sometimes can be quite cumbersome, and not only that, but confining, because then you know you can't go outside of it if you're being so specific. Right. I wondered if you would not reflect on this aspect and find that might be the way in which it was actually designed in the bill might not be a better way to go.
Well, when this part was being considered, when this part was being considered by the board, we didn't really look at the institution in To be honest, I can't respond to this.
You have heard it. Might it
Right.
not be dealt with by...
It could have been dealt with
It could be
under
dealt with.
institutions broadly. Yes.
Mrs. Senator Fraser-Binns.
Thank you, Madam Chair. Mrs. Headlam, thank you for your presentation.
Thank you.
I just want to ask you something on the last point, last recommendation you made. And I think you said that the tribunal should be empowered to request the parties to do restorative justice session.
Right, yes.
And mediation. Is that what you said? I wasn't quite sure. Yes.
Yes.
Restorative justice.
And counseling sessions
and counseling
separately.
sessions, right. And, you know, I do believe that that is a very worthwhile and a good recommendation, particularly because of some of the issues we discussed in your presence earlier in terms of the trauma and the psychological effect that this will have on the person in the future and at present. So I think it is good. I wanted to, well, and I believe that it is covered under 34(1)(b)(2). And it speaks about the direction that it can give to the respondent. But I wanted to find out from you, in terms of the restorative justice, how do you see this working? You know, how do you see it working out? Restorative justice between the parties.
So in the event that the parties, after the hearing, in the event that both parties have not been able to work out their differences, then restorative justice would assist them to not take their, what you call it now? Yes, their grievance any further, and to bring some closure to their differences.
If I may, Madam Chair, because I do believe it is a very worthwhile recommendation, but again, bearing in mind the nature of the offense, do you not think that it would be a lot to ask of the complainant by way of mandating the complainant to subject himself or herself to this process?
Well, not really, because how would they get past the problem?
Explore other options of personal counseling.
Right,
I think it's worth a recommendation, but the only challenge I would have is the mandatory side of it.
The mandatory, okay.
Madam Chair. Okay, thank you. I just wanted to follow up, Mrs. Headlam, on the matter raised by Senator Fraser-Binns. One, I want to agree with her in the first place that processes like mediation and restorative justice can't really be mandatory because you need two willing parties, and that's the first place you start. Right. So if it is a recommendation, I'm fine with that. I also would prefer for us to be looking at it not at the end. It would have to be somewhere in between. And then the completion would come back to the tribunal to see if that process has been able to resolve the issues or if more is required. I mean, I'm pleased that you have sought to include a process like that into it, because so often we believe we narrow the disputes that could benefit from a restorative justice process. So that is important, but I think we also need to be clear that it can be mandated and it is often best used as a part of the process. And so after that, they come back and then you're able to decide how you go forward from there.
Yes, I agree. Thank you. Oh, I was saying I agree, and I was thanking her for her suggestion.
Thank you, Chair. I just want to congratulate you for your presentation also, and just to underscore that your recommendation regarding the psychologist on the tribunal is one that we've had and we raised and such, and it is quite unanimous. But also to, well, I'm assuming that by now, because it has come up so very often. But just to underscore that it's not necessarily a psychologist, but someone with psychological training. Who can relate to such issues.
Yes. Yeah. Okay. Yes, I agree with your recommendation as well, and it would be good to have somebody with that training on the panel.
Okay, MP Crawford.
Thank you, Madam Chair. Thank you for your presentation.
Thank you.
My comments, I want to add my own support for the recommendation for the expansion of institutions to include particularly churches and sports clubs. I heard the comment from my colleague senator, but I think oftentimes we overlook some very critical spaces that perhaps we consider them safe havens, and I believe the church could easily be considered such. The church accounts for very large bodies of people, and just like the schools being brought to the center, clearly under the institutions, I believe, if no more, the churches should really come to the front, and I support the recommendation made at Section 25 for provisions to be made to allow children to make complaints. We have to ensure as a committee with this major responsibility that this bill protects persons in spaces or persons that are usually or the likelihood of them being overlooked. We have to avoid that. So I really support the call to include churches, especially under other institutions, and facilities. Thank you.
All right, thank you for that. And I endorse what you have said as well. Under Section 25.
Okay, thank you. Any more questions? Okay, Senator Gale.
Just a clarity on something, and maybe the technical team can help us. So where in 36, the representation is for institutions and facilities to be named so specific, which may include a long list. In another legislation, we speak about a person conducting business, the occupational safety and health legislation. And I'm wondering if it could be considered to have it, under a rubric, rather than we outline the specific institutions in the legislation.
Okay, I think at this point, Mrs. Robinson? Yes, Mr. Bailey, please go ahead.
Actually, I just want to inquire of Senator Gale. He made reference to Clause 36. I think we're a little confused here. Clause 36 speaks about any person who is dissatisfied with a decision or award of the tribunal.
It was pointed to Section 36 in the presentation, so I just jumped at that. It might not be that. Not the clause.
I think, well, not sure to answer that at this point, but one consideration that perhaps, just to remind the tribunal, the committee and those assembled here, the idea behind this bill is that in every place of business, commercial institution, whatever that falls under this, that there would be a policy So if you're going to your gym, which is a commercial entity, for example, that basic policy that people should not be sexually harassed would apply. And under the provisions of this, there is a standard form, basic anti-harassment policy that should be affixed in the entity. And that is at least the very basic standard that should be complied with by all. So whether or not the institution is named, or the entity or the type of entity is specifically named, that would be the case, is my understanding. So it is frankly a policy matter, I think, for the committee to determine as to whether or not they would prefer to see these things specifically, or particular entities specifically named.
And this would be aligned now or become compatible with your earlier presentation regarding policy, where different industries may have their own defined policies.
Yes.
Okay.
But again, those policies, that code that I speak about,
the code that you spoke about,
would have to comply with this legislation, and in fact wouldn't be very useful as a code unless it's going to be more specific, it's going to particularize, and it is going to have a higher standard than what is set as the floor by this legislation. If I may, though, there is something that Ms. Headlam raised in relation to Section 9 in her itemization at number 3, that landlords should not utilize technological instruments such as cameras to spy on their tenants or invade their privacy. Now, this is in fact, in other jurisdictions, serious criminal offense. I would just indicate that there has been a pending review of the Cybercrimes Act for some time, and certainly my department is working on it. And part of part of our concerns would include matters such as this.
Thank you, Mr. Bailey. MP Brown-Burke and Senator, you're slipping away. All right, thank you. Thank you so much for coming. I think you have very important business, other very important business, which you have to attend. Good luck. Good luck. Yes, Mrs. Robinson from the Bureau of Gender Affairs, please go ahead.
Right. Thank you, Chair. I noted earlier that in the presentation, very comprehensive presentation, the person from the Rent Assessment Board, I noted that you mentioned that in terms of reports coming to you, you do not routinely capture reports or to pursue the cases. Perhaps you don't have the facilities or so on. But the question to that is, do you have a plan to accelerate the cases, and how do you plan to have those cases sent forward so that they can be heard? Because if you notice in the bill, it speaks to the mechanism that allows for the tribunal, when it is established fully, to listen to and address the cases. So that would require you to pass the information onwards. Since it is the Rent Assessment Board is one of the only entities that exist that would deal with persons in accommodation who have issues with sexual harassment. So that's one question. The other is there a mechanism for collecting data that would relate to tenancy and persons who are in landlord-tenant situation that's brought before the board? And thirdly, do you have a mechanism in place that will allow the Rent Assessment Board to give support to this bill, considering that landlord-tenant situations are very sensitive, and in some cases there's a burden of proof based on the relationship between the landlord, the very precarious relationship between the landlord and the tenant? Those are my questions.
As it relates to your first question, the board having looked at this bill will now be putting things in place to facilitate us giving information when necessary. And as it relates to collecting of data, information from our clients, we do have a mechanism in place to capture our information. However, as it relates to sexual harassment, that is not included in our records. And did I answer the first question?
So it would be necessary to include it in your records?
It will now be necessary, yes.
Yes, it would now be necessary.
Yes, it will be.
Thank you. I think there's one more point I want to make. You mentioned the issue of awareness raising, sensitization. That is something that's very important. Would you be amenable to a conversation between the Bureau of Gender Affairs, which has in the ministry that remit of ensuring that the sensitization and awareness raising takes place around the issue of sexual harassment, so that those bodies that are within your jurisdiction would be able to get such sensitization and awareness training?
Yes. We will accept any training or any information that we can to pass on to our clients. Yes.
All right, thank you. Thank you so much, Mrs. Hedlam. Senator Campbell Rodriguez.
Thank you, Minister. Just going back to the point made by Senator Gale earlier, and Ms. Hedlam's response, read the clubs and societies. If we look in part 2 on page 5, that whole section on prevention of sexual harassment, I think last week some of the presenters also mentioned expanding the places that are, that the bill refers to, gyms, clubs, church, etc. In part 2, the language here speaks about employers and employees. So it's a lot about the workplaces, the business place, and it talks about institutions. But if we look in section 6, and where it says a person in charge of an institution, could we not change it to in charge of an institution, entity, or organization? Because I think that would then take into consideration the gym, the church, rather than listing each of them, because we run the risk if we start listing that we may overlook something at some point. So I think if we list it out, not just institution, but entity, organization, that may help. I don't know from the technical people if that could work.
Ms. Grant or Mr. Bailey, you want to take this one, please? Ms. Hedlam, could you turn your mic off? Thank you.
I understand the suggestion and the concern. However, the way the language of the bill, so the word institution is defined in a particular way as including, and it sets out several things that it includes: schools, correctional institutions, etc., and ends at subparagraph G by saying such other place or facility as the minister may by order publish in the Gazette designate as an institution. So the concern can simply be met by what is already provided here, where it is open to the minister responsible to designate place, such place or places for the purposes of this. So rather than having to multiply the words by using entities or organizations or things like that, it can stay under institution. It could be covered by this, by what already exists. And if you introduce those words, then you would, since institution is defined already, you'd also have to define those words, either to mean the same thing as institution or to give some other different meaning to them, which of course creates another level of complexity.
But guide me here. Is the gazetting retroactive? So, for example, if Senator Gale has a case before the tribunal and the minister had not yet designated such had not yet designated such a place, could he or the minister then gazette in the middle of the tribunal carrying out its case?
The short answer is no, and I can just hear my colleagues from the Attorney General there. See, they're here standing on the back of their necks.
Right, so that's why I don't think using that option that you're mentioning would work, because it would only work if it could happen because if you won't know, I think it's much easier for us to add on to the definition of institution than to a case, as again using an example, if a case is before the tribunal and the minister had not yet, designated such a place as per the law, then that case would automatically get thrown out because it doesn't exist. Unless I'm misunderstanding.
No, I think you think that's correct, but and that is why, in fact, I think some previous comments were made in relation to if the committee in its wisdom would like to add or recommend the addition of other specified entities or organizations such as churches and the like, that is a recommendation that is open to the committee in its wisdom to make, if it would seek to do that. The provision as it stands now was made to deal, is in fact what we'd call a boilerplate provision that is usually made so that it can be future-proofed as best as possible where circumstances may arise and the minister may need to act. In those circumstances, it would definitely not be retroactive. But if from the beginning of the life of this bill, that if the recommendation of the committee feels that these other things should be specified, should be named and also added, that is something that is fully within the remit of this committee. It's a policy decision.
Thank you. Ms. Campbell? Mrs. Rodriguez?
Yes, I just think, given that it's not retroactive, we should look as a committee when the time comes to adding in the word organization, because it would take in churches and all the other entities that have been mentioned by several submissions.
Ms. Grant, you wanted to make a point?
I was just looking at subparagraph F on the institutions that says a place for the use of any facility by members of any organization, and certainly in relation to what you said about clubs, I think that clubs could fall under here. Churches could also fall under here. I take the point you have made, Senator, and it is something when we get to the matrix stage we can have more robust dialogue on. But as my colleague, Mr. Bailey, said, we have to be careful in terms of how we break things out, lest we confine ourselves so much into a space that when it's time for us to break free, we can't break free. So.
Thank you. Because we have to look at the hospitality industry, such as hotels and so on. That's a matter we have not really addressed. So at committee, when the committee is deliberating, we may wish to look at those areas. All right, I want to thank you so much, Mrs. Headlam, for your presentation.
Thank you very much for having me here to represent the Rent Assessment Board.
Thank you. And the Bureau, I know, will be in touch with you.
I look forward to it.
All right, thank you so much. The coffee and tea is available just outside. You don't have to walk down the hall. So if you wish to go grab a sip. But we will go now directly to the presentation by the Norman Manley Law School, Mrs. Karen Seymour Johnson and Ms. Janet Levy. They're here to make the presentations. Now we will ask you to proceed. Thank you.
Thank you. Thank you, Madam Chair. Just again, by way of introduction, my name is Karen Seymour Johnson, and with me is Ms. Janet Levy, and I want to extend and register the Norman Manley Law School's gratitude for the committee extending invitation for us to make our submissions here today. And we are indeed grateful to be a part of these debates, and we certainly look forward to this opportunity to give voice to this debate. Now, the Sexual Harassment Bill is without a doubt a meaningful and timely legislative work. We commend this committee for taking this bold move to tackle a very troubling yet sensitive issue in our society. Ingrained in our society is the notion that persons, particularly those in a position of power, are entitled to subject others to sexual overtures, ranging from gestures to overt sexual conduct. The effect of this bill will have a profound impact on culturally accepted norms and will require behavioral and ideological changes in the way members of our society relate to one another. Rigorous and sustained public campaigns as well as training of relevant persons will be necessary to deconstruct ideas about marginalization, sexual objectification, humiliation and abuse, and thereafter reconstruct notions of more acceptable forms of social behavior premised on equality and respect. We are very pleased that the Select Committee, in drafting this bill, has recognized, amongst other things, the need for the bill to be gender neutral, as either sex can be victim or offender. Now, my colleague and I looked at the bill, and we looked at the different sections, and we submitted certain recommendations to the committee. And we'll just go through them very briefly. In part one, which speaks to the preliminary section, and in particular section 2, in keeping with the items already listed there, we thought that it would be very useful to define what is meant by workplace. And I know that we have been spending a lot of time talking about the different organizations and institutions, but we noticed that there was a lack of definition for the word workplace, and I think that it would give certain clarity to that space for which these offenses do take place. And we note that there is a definition in the Canadian Labour Code, and we put it for your recommendation. It says, any place where an employee is engaged in work for the employee's employer. And the Employment Sexual Harassment Prevention Act of Barbados also speaks to the definition of workplace, so I think it would be a very useful addition to the bill. References to the court throughout the bill should be extended to the Supreme Court. Presently, the bill does not contemplate a ceiling on the amount of compensation to be awarded by the tribunal. Therefore, the bill must extend the meaning of the court in respect of Section 2 of the jurisdiction of the Supreme Court and not limit it to the parish court. Under Part 3, which deals with forms of sexual harassment and related prohibited conduct, we looked at Section 14, Subsection 2, which speaks to the members of the hearing panel of the tribunal. However, the wording is not clear, and we are not clear as to whether the attorney at law appointed shall be the chairman of the panel with one other member of the tribunal appointed to sit on the panel, or the chairman of the panel will be the third person on the panel and will sit on every panel to hear and determine each complaint. So the section we are suggesting that it be looked at again and reworded so as to avoid any confusion. In relation to Section 15, Subsection 2, it is recommended that the notice by a member who has an interest in a matter that the tribunal will hear be served prior to the hearing of the complaint so as to avoid any delay in the commencement of the matter. If this is done, another member can be put in place so that the member required to give a notice is not present at the tribunal hearing in respect of this matter. Under Part 5, which deals with the Sexual Harassment Tribunal, we know that there was much discussion, and I think it seems to be a settled issue. We agree that there is a need for the establishment of the tribunal that is specifically dedicated to the hearing and determining of these matters, particularly because of the sensitive nature of the offense and the impact it has on work relations of persons involved. We turned to Part 6, which dealt with procedure for making complaints, investigations, and hearing by tribunal, and we looked specifically at Section 25, which speaks to making of a complaint to the tribunal and posits that this shall be made within 12 months of the alleged contravention. It is our humble submission that the period for making this complaint, particularly in relation to Section 25, Subsection 1, should be extended to 3 years. We feel that there is a need to recognize that victims, both male and female, of sexual-based offenses often do not report incidents immediately after they happen. Several studies confirm this for victims of rape, sexual assault, etc. Many fear exposure, rejection, or any adverse personal backlash or public ridicule. Many are crippled by the emotional and psychological impact of the harassment. So it must also be recognized that each victim has his or her own coping mechanism. Therefore, allowances will have to be made for victims to find the courage to come forward, especially vulnerable victims such as children. Additionally, the bill contemplates that the complainant will seek to exhaust the internal mechanism before lodging a complaint to the tribunal. It is understood that this ought to be the norm in terms of bringing a complaint so as not to overwhelm the tribunal with matters which could otherwise be dealt with internally, notwithstanding the provision of Section 25, Subsection 1, Subsection 4, which gives the victim right to apply to the tribunal to have his or her matter brought to the attention of the tribunal and heard by the tribunal, notwithstanding that there may be internal mechanisms in place. This, we believe, could result in a complainant, this approach is advisable. The internal mechanism indicated in subsection 3 may require considerable time, especially in cases where there are more than one complaint against a single offender. This could result in a complaint being ruled out of time and would be unjust. Consideration could also be given to the recommendation of a provision for a complainant to apply for an extension of time to file a complaint upon reasons being given to the satisfaction of the tribunal. We had posed some general questions to the Select Committee, and it is for your consideration. So we posed a question, or one of the questions we posed was, does the legislation contemplate the position that a person in authority may be sexually harassed by a subordinate? It is our submission that if the bill aims to create a safe environment for all workers, it should extend to the context of sexual harassment occurring in the other direction, that is, worker harassing a supervisor or manager, as well as a colleague to colleague on the same level. The other question that we posed was, is there an obligation on the victim of sexual harassment to verbalize or communicate to his offender his feeling of being offended? The UK legislation, the Protection from Harassment Act 1997, actually addresses that issue, and it's something that we commend to you for your consideration, where it says that the offender is deemed to know that his conduct is harassment if the objective person being in that situation would have felt that the act or the conduct was considered to be harassment. So that is something that you may wish to consider, whether the complainant or the victim has to verbally communicate or communicate in some way how they feel about the conduct that is being directed at them. The other question that we also posed was, will the ministry be equipped to investigate and monitor employers' compliance with the legislation? There is a great deal of responsibility placed on employers to ensure that there is compliance with the legislation, implementing policy, so forth and so on. And so the question is, will the ministry be equipped to take on this role? The last question that we posed was, will the bill contemplate sexual harassment that takes place at the workplace or institutions towards others other than employees, such as customers of a business place or visitors at an institution? It is our submission that the bill should be comprehensive in its scope to protect workers at any level from sexual harassment by third parties during the course of their employment. In closing, we submit that it is recognized that Parliament, and by extension this Honourable Committee, in drafting this bill sought to address sexual harassment in the context contemplated here, namely within the work environment or workspace and the various institutions that are being contemplated at this time. We urge the committee to consider the harmful effects on victims of sexual harassment, not just in the context of the workplace or institutions mentioned in the bill. Sexual harassment goes even deeper and further than what we are presently contemplating, and many times results in acts of violence and even death. Most, if not all, victims simply want to be able to live their lives and go about their businesses without being harassed. They just want the conduct to stop. Oftentimes, the perpetrators are persons of great wealth, power, or influence, and are only deterred by the threat of criminal sanctions. Hence, the call for sexual harassment to be criminalized. We know that the Senate has adopted a recommendation to review the Sexual Offences Act, and we ask that there is some consideration being given to include offences such as stalking when the time comes in relation to the Sexual Offences Act, if it is that the scope or the remit of this bill will not extend to the criminalization of sexual harassment. And just pointing to the different legislations in the region that have already criminalized sexual harassment, and I make mention of the Employment Sexual Harassment Prevention Act of 2017 from Barbados, the Sexual Offences and Domestic Violence Act from Bahamas, and in the UK, the Protection from Harassment Act 1997 and the Protection of Freedoms Act in 2012. They have all criminalized sexual harassment. In fact, in relation to the Protection of Freedoms Act, there is a provision that both the civil remedy and the criminal remedy run side by side. So there is remedy for the victim in the scope of the criminal court, as well as the civil remedy that is there afforded to them. Interestingly, I believe one of the members, if not one of the invited guests, may have asked the question as to whether or not there is any other territory or jurisdiction that has a larger or a more extended period, rather, for the limitation in which the complaint can be made. And when I looked at the UK legislation, the Protection of Freedoms Act, it actually speaks to the fact that the Limitation Act of the UK does not apply, which meant that there is no bar, no statute bar in terms of limitation for seeking civil remedies in respect of sexual harassment. So I just wanted to add that final point there. If I can be of any further assistance to Madam Chair or any of your members.
Thank you so much. Your presentation has given us a lot of food for thought. I'm going to invite Mrs. Robinson or Miss Grant from the ministry or Mrs. Robinson from the Bureau of Gender Affairs to maybe give us a brief response to the question that was asked. Will the ministry be equipped to take on the role of administering this legislation?
I think that's the last question, Madam Chair. The last one that was asked, was it?
Second to last.
Okay. All right. Well, certainly as it pertains to what the bill provides for now, the authorized officers who will be attached to the particular agency right now, the bill says the Bureau of Gender Affairs, they will be responsible for securing observance to certain sections of the Act. So in terms of being equipped, yes, the ministry will be equipped in the form of those persons. As it relates to, did you ask a question about sensitization or something to that effect? No?
No.
No. Okay. Your time is up.
Right. I thank you for your presentation. It was extremely comprehensive. I could follow very clearly what you were saying. I concur with what my colleague, Ms. Grant, mentioned concerning the authorizing officer and the remit under the Bureau. And I also wanted to raise the point here about the section you mentioned about the welfare officer. I quite like this because it means that you have identified, or you will identify a person or a group of persons who would be considered as welfare officer. And that person would have the remit of ensuring that whatever that designated, it says here, who shall receive training and sensitization, and this person would be charged with the responsibility of the sensitization campaign within his organization. I quite like that because it means that you have taken this very seriously. So the issue that was raised by Ms. Grant about the authorizing officer, that those persons, the authorizing officer and the welfare officer, could work together, because the authorizing officer within the Bureau would be responsible to make sure that the cases are taken, the cases are heard, and they are prepared for the tribunal to hear. The welfare officer could be the liaison person, or if you have a number of those persons who would be poised to, having had the training and the sensitization, to take the matters further and to ensure that it gets followed through. So this suggests that there's going to be a working together and a collaboration, which I think would be very useful.
And very necessary.
And very necessary. Thank you.
Senator Johnson-Smith.
Thank you, Madam Chair, and thank you for your presentation today. I thought it was very interesting, very well researched, and I'm hopeful that the technical team will provide us at some point with copies of the legislations that has been referenced. Barbados, Bahamas, UK, which I think will help all members in considering more deeply some of the points which have been made. Just a few points, if you'll permit me, Madam Chair. The first was regarding your hope that the matter of, well, actually, let me not start there. Let me start at the first question regarding the legislation contemplating a person in authority being the victim. When I read the definition of sexual harassment, it was absolutely power neutral. It spoke of the impact. So it speaks of sexual harassment being any unwelcome sexual advance towards a person by another person, which is reasonably regarded as offensive or humiliating, etc. And it's a point that I've often looked at, because I recall when we were discussing bringing the matter, bringing the bill back. I remember a female attorney saying to me, the sexual harassment should only occur, should only be provable where the person is in a person of power over an employee. And I was saying, but the actual creation of the feeling of harassment, of an environment in which, a toxic environment, is not necessarily related to the decision as to whether you can be employed or promoted or demoted, etc. It's much broader than that. That's where maybe the jurisprudence started several years ago. I mean, when people just started discussing this. But I read it as being neutral. So what I wanted to know was whether the law school was seeing something else in the bill that creates that perception that we should be looking more closely at as a committee. Regarding the query of an obligation to verbalize or communicate the feeling, I didn't locate this in the definition either. So again, my question is, were you picking up on something in the language that made you think, or is there jurisprudence which you think the statute needs to counterbalance by making a point like that, which I would imagine to be evidentiary, whether that should be referred to? And my third question is regarding the point about sexual harassment taking place with customers and visitors, etc. And this is related to your final point, which is about the recommendations of the Joint Select Committee in respect of the Sexual Offences Act. I think, Madam Chair, that some of what we're discussing here as a committee, and it will be very important for us at a later stage, much of the discussion is taking place in the context where we don't have a criminal act of harassment. So we have been quite clear that the Offences Against the Persons Act needs to be amended to have a criminal act of harassment that takes place at large. The person who has no relation to you, following you from the bus stop to your house, the person spying on you when they pass, not necessarily your landlord, your neighbor. No relation, just someone who is harassing you. Much broader, needs to be criminal, and in creating that offense, it will become an offense under the Cybercrimes Act as well, where the police and the DPP have also asked that, this crime is needed so that we can criminalize it by operation of the Cybercrimes Act. So that is there. And I think the challenge that we're having with some of, and my first committee meeting, so I apologize if it's been dealt with otherwise, but it seems to me that some of the discussions that we're having are as a result of an expectation that the Sexual Harassment Act, which is really supposed to deal with that workplace environment, not on the basis of power, but it's supposed to be based in that situation, is now being viewed as a large, as at large, as a matter of fact. And I think that's partly why we're having a challenge with the institutions and organizations and where it's not being covered, because we're not focused on the fact that there's sexual harassment, which is appropriately dealt with by a tribunal because of the relationship between the parties, sensitivity of employer-employee, you want to continue in the work, this is not, sensitivity of landlord and tenant, as opposed to the broader concept of harassment, which can take place between anyone at any time in any place and appropriately dealt with criminally. So I think that it's something that the committee is going to have to think about very deeply, Madam Chair, and technical team, in terms of guiding us. If the policy is not to go beyond, and this is one of the reasons I want to see how Barbados dealt with it, I want to see how UK dealt with it, and Bahamas. If this is a separate type of treatment, then I think we may need to look at it, but it may well be that we just need to be more clear that this is the policy scope of this act. We don't want to set up a tribunal that can't manage the matters because the types of matters that are coming are beyond anything they could have contemplated or are resourced to do. We want a body that can work for the scope of work that has been set for it. And then in respect of the criminal act now, the one that, this is lock-up business, that has to be dealt with under the Offences Against the Persons Act, or even sexual offenses, but treated criminally in the appropriate space. So that wasn't a question. clearly, but I really would appreciate if you would guide us if on the first three, if there are things that we're missing, or if there are things that you think need to be strengthened in terms of what could be here. Thank you, Madam Chair, for your indulgence.
Thank you, Senator Johnson-Smith. Do you wish to make a comment, Mrs. Johnson, or Ms. Levy?
May it so please you, Chair and members, as it relates to the question of verbalizing the conduct, it's an issue of consent, or whether or not the offender is aware that the act being done is actually causing some harassment to the complainant. The question, part of the discussion we thought also is that we're aware that this is publicized, and we wanted to have more communication on the issue. And so some of the questions posed is really to highlight the issues that I believe the general public may have in understanding the operation of the legislation.
Okay,
Thank
thanks
you.
very much.
Senator
just a follow-up.
You good?
Sorry, just one follow-up. Just on the point of the verbalization, because it seems that you agree with me that it would be evidentiary. But the question is, what I wondered was whether there has been case law that would make it appropriate for us to say it will not be, that it is not necessary. Just like, in rape, you don't have to have had said no. Is it that you are contemplating that the legislation should say that the person need not have verbalized that they feel offended, or that the advance is unwelcome? Because I see that if there's a power dynamic that has to be treated with, clearly it is unlikely that the person will have said that you're making me uncomfortable is something that everyone does not feel empowered to say. And it is in fact the most vulnerable person who will not feel empowered to say so. So I'm just trying to get the thinking behind it so that when we're discussing it as committee, we can unpack it a little more.
Yes, thank you for your question. I think, and I agree with you, that it is really an evidentiary point, because whether it is in a court or in the tribunal, the issue of proof that this conduct was in fact one that could be classified as harassment, the question will arise as to whether or not, what is the circumstances, the relationship between the two. I think there was some example given here today about the relationship between I think it was a landlord and a tenant, and that there was this consensual agreement. And so if after that, or even in a situation where there may be an issue as it relates to the conduct of the victim, evidentially that would be something that will have to be raised or considered in terms of proving that the victim felt some kind of shame, embarrassment, what have you, in respect of that. So I think it becomes very important because, and as I had pointed out, the UK legislation actually speaks to it. And so I think that perhaps we could consider indicating in some way in the bill that it ought not to be mandatory or a requirement for the victim to indicate verbally that she is or he is displeased with the conduct. Or alternatively, you could have a situation where you say that it could be communicated by words or conduct or both. Some legislations actually speak to the phrasing in that way. But certainly it should contemplate a situation where, as you indicated, especially where you have persons who are particularly vulnerable, and persons will respond in different ways. And so it should not necessarily be made mandatory that the victim communicate. But I like what the UK legislation does. It deflects it in a way that says, well, if a reasonable person in these circumstances looking on would say, but this conduct is harassment, then the offender is deemed to know that his conduct is harassment. So I think that is something that we could definitely look at in terms of proving, proving the conduct and the context in which the thing happened.
Thank you. Senator, Senator Johnson-Smith, Senator Gale?
It's a very thought-provoking presentation that would have identified some areas to which the committee or the bill may have missed, and there are some areas that would have reaffirmed some positions that would have been represented earlier. And I speak about the question of, will the bill contemplate sexual harassment that takes place at the workplace or institution towards other than employees, such as customers? And there was previous presentations which looked at the fact that you are an employee in an organization that has to interface with customers or clients or suppliers. And there ought to be a commitment from the employer or the person conducting the business to give or aid in that protection. So this approach is one that is accepted by the committee and is commendable. The obligation on the victims of sexual harassment to verbalize or communicate. I remember dealing with a particular matter, Chair, where the alleged perpetrator indicated that there was no evidence put forward by the complainant to suggest that she was being harassed. And what she represented was an email sent to him indicating that you are harassing me and you need to desist. Now that would be taken as evidentiary before a tribunal. In that, there would have been the first line of defense to say stop, whether verbally or communicated otherwise. The question of the welfare officer. I like it, but I want to put a different spin on it because you have some employers who might not want to designate or having their employee, whilst I'm for creation of employment, they might not want to say we have this welfare officer that is going to be so defined to treat with that. But I would prefer to designate the responsibility in a particular job scope to ensure that this is treated with, rather than just limited to having a welfare officer. There's a part that I'm grappling with, and it came out in a little way, Chair, in terms of will the ministry be equipped to investigate or monitor employers' compliance with the legislation? Now I believe this is key in terms of the compliance because Clause 4 spells out the duty of the employer and the person in charge and the duty to ensure environment is free of sexual harassment. And it lists a gamut of areas. But I was trying to scour in terms of what would happen to that employer if that employer was in breach or did not align itself to what is required in the legislation. And we may have to contemplate where an employer may have been in breach or is not in compliance. The last point is that what I found again intriguing was your reference to Part 6, Section 25, and that last statement where there are more than one complaints against a single offender. Now, we saw a situation where one complaint came out against a particular manager in an organization. And it triggered an investigation. And then at the point of the hearing, you had more than one persons now in the department coming out because they now have the confidence that someone stepped forward. And so the deliberation was a little bit confused because we said, are we going to hear that single initial case or are we going to hear them collectively? But then I said that each should have its own merit, being the defender in this case in terms of the complainant. And so each would have had its own merit. But then, depending on the length of those hearings and the process of the investigation, you may surpass the 12 months that is placed here as being considered. And so that is one of the reasons now that we must, and we are compelled in treating with defining a reasonable period, because you may have a situation where more than one complainant is being represented against a single individual or perpetrator. And so I found this chair to be extremely thought-provoking and something that we really need to look at in terms of how you treat with these particular cases within the confines of the institutions or organizations before it goes to a tribunal. So those would have been my comments. Thanks, Chair.
Senator Johnson Smith, Ms. Georgette Grant, and then MP Crawford.
Thanks very much. And I'm making a comment on Senator Gale's intervention, which may allow you to also say something further as well. I could ask, do it by way of question. Because in 25.5, or rather 25.4, allows the tribunal to grant leave to make someone, to make a complaint outside of the usual time. It allows the tribunal, gives the power to expand time. And 5 specifies that this can be done where they show cause as to why the person reasonably believes that their rights may be prejudiced if the time were insisted on, so far as I understood, or not going through an quote-unquote internal process. And it deals with that separately from where there is no internal mechanism as a reason for the tribunal to allow more time. So what I would love to know from the technical team, including you, Madam Counsel from the BGA, is whether this is sufficient to address the concerns which are being raised both by NMLS and by Senator Gale, or whether the provision would benefit from any type of presumption where there are more than one complaint. We have had presentations, Madam Chair, 3 years, 6 years. I think we're pretty much clear that it will not be 12 months. So the question is what circumstances would reasonable, rather than delineating or designating specific circumstances, do you feel confident that this provision is sufficiently effective as it broadly allows the claimant to show reasonable cause why the claim is brought later? And I would imagine, that because there were 14 cases against the same manager, and it took HR forever to get to mine, would be more than reasonable cause. So the question is do we need to be more specific here, or do you feel confident in the breadth of this language? Thank you very much.
Thank you.
Thank you, Ms. Grant.
Yes, Madam Chair. Senator, as it relates to 25, subsection 4, the short answer to the question is I think we could benefit, this particular provision could benefit from clarity, because what subsection 4, as it relates to the enlargement of time issue, where you have a series, because what subsection 4 allows for is where you have internal mechanisms and you're supposed to use those internal mechanisms, exhaust them fully before you come to the tribunal. But even if you have not done that, then the tribunal will allow you to come before the tribunal and make your case regardless of the fact that you have not complied with that provision in subsection 3. There's another part in the bill that speaks to the series that time starts to run from the commission of the last act in the series. So for the avoidance of doubt, I think subsection 4 could benefit from some clarity, so that if a person finds his or herself in such a situation, there wouldn't have to be any guessing and spelling as to how that would be treated. But then again, the discussions we have been entertaining surrounding the extension of the time limit, that as opposed to the 12 months, it may or may not take care if we extend the time limit to the series and how time runs from the last act in the series. So all of that we can discuss. But I think the provision could benefit from clarity. And Senator Gale, as it relates to what you said about consequences that an employee, I think, would be made to bear if he or she does not comply with, is it clause 3 that speaks to every reasonable effort to make the environment free from sexual harassment, and the prescriptions in 4. Part 4, that's clause 10, that deals with the authorized officer. The authorized officer under paragraph A is responsible for investigating and securing the proper observances of sections 3 and 4. So when the authorized officer upon visiting your business place realizes that according to section 3 you don't have any policy statements and you have not complied with all the things that should be in the policy statement, then according to subsection 3 in same 10, it gives you 30 days, he or she would give you 30 days to comply with the direction. Put your policy statement in order, do this. If the 30 days pass and you still have not actioned that, then it's an offense it's an offense in the parish court, fine not exceeding $1 million. So I hope that answers the question.
Thank you, Ms. Grant. MP Rhoda Crawford.
Thank you, Madam Chair. Madam Chair, I note that this is the 3rd sitting of the new committee. Already we've heard 6 submissions. And of the 6 submissions, 4 of the submissions speaks to clause 25.2, the complaint period, the recommendation to extend beyond 12 months. For the benefit of the committee and the technical team, my question to the representatives from the Norman Manley Law School: why a recommendation of 3 years as opposed to 4, 6, or 2? What's the rationale?
Well, when we initially thought about it, our consideration was that 12 months was definitely too short a period. And then there's also balancing the scales to ensure that matters don't stretch out, or you don't have matters that are coming, 10, 15, 40 years down the road. And so you want to ensure too that any evidence that can be brought before the tribunal is still available within a certain time. And so we thought that a 3-year period, taking into consideration the different types of victims that you can have, or that the bill actually speaks to, thinking about children and any other vulnerable party, as well as persons in the work environment, may certainly need some amount of time to come to terms with what they are dealing with, and also to be able to, as I said, exhaust the the internal mechanisms first so that they are not out of time, and which is why we also made the recommendation, if the 3-year period was not deemed suitable, for the inclusion in the Act to have a provision for an application for extension of time, given certain grounds or the tribunal being satisfied that these conditions warrant an extension of time.
Thank you. Right, so at this point, I think we can, Senator Morrison, MP Morrison.
Thank you, Chair. I am right there with Senator Johnson-Smith, where she mentioned about establishing certain parameters as it pertains to this bill and not just operating at large. And Senator Johnson-Smith, I think it is because this issue has been such a volatile issue that people believe has languished for so long that many individuals, want to have an input and they discuss it at the broader level. And Norman Manley Law School, the first question, does the legislation contemplate the position that a person in authority may be sexually harassed by a subordinate? Like Senator Johnson-Smith, I do believe that the bill properly defines it to exclude the mischief that you are trying to safeguard. And I can understand why you were going there, Norman Manley Law School, because we have to keep putting into focus the fact that there are stereotypes in our culture as to who the aggressor and the offender is. So I just see this as your wanting to ensure that we do not ride along with these stereotypes. One of the issues that I am concerned with is that we have the tendency to make rules, tough laws, but then we do very little in terms of maintaining and upholding them. And in order for this to be as robust and effective as we want to do it, I am agreeing with you, Norman Manley Law School, right at that, your literature that says that rigorous and sustained public campaigns as well as training of relevant persons will be necessary, and this is the part that I'm finding charming, will be necessary to deconstruct ideas about marginalization, sexual objectification, humiliation, and abuse, and thereafter reconstruct notions of more acceptable forms of social behavior premised on equality and respect. I'm liking that because we operate in a culture that normalizes certain behaviors. And even when we have gone through, Madam Chair, and this comes into effect, we have our people who we will need to socialize, because many of them, they are not even aware that they are in violation. Many of our people, they don't even know about basic human rights and the fundamental rights of the person. Thank you for your presentation.
Thank you, MP Morrison.
Madam Chair, if I just may add, when I was going to school just, 3 years ago, and I'm speaking specifically of being in prep school, we had what was called civics. And I know in some way our curricula has now tried to bring back those topics, that subject on the primary level as well as in the secondary schooling. But I think that it will start with our young people. It will start with our young people. If we are able to change the mindset and the approach and the thinking and the beliefs of our young people, of our children, we indoctrinate them about so many other things. And I think it's time that we start to invest in our children. We think that we need to fix us. We are the adults, so we need to fix us. But I think that if we're really going to see sustainable change in our society, we need to address the issue of education. Education is not all about books and, good that we're learning about math and English and stuff like that, but social values, it's very, very critical in the sustainability of what we're talking about here. When we talk about issues of equality, issues of respect, we can call a spade a spade. In Jamaica, we have a challenge with that concept of respect, and at every level. And so it is very important for us to target, and aggressively target our children so that when they sit here in another couple of years, they can perhaps have a different perspective, a different world, a different context in which to operate with each other. Thank you, Madam Chair.
Thank you very much. I want to really thank the Manley Law School for your presentation this afternoon. You've certainly given us a lot of food for thought.
Thank you for having us here, Madam Chair.
We really appreciate it. And so, at this point, we've come to the end of all the presentations. Our next meeting, which is next week, Thursday on the 26th, we have two presentations to hear. The Jamaica Independent Council for Human Rights and Jamaicans for Justice. We have limited the number next week to 2 presentations because of the organizations that will be making their presentations, and which we expect could be quite lively and very comprehensive. So I just want to thank you again for coming. I want to thank the technical team, and I want to thank the members for turning out in your numbers. And I look forward to seeing you next week. Will someone so move? So moved by Senator Campbell Rodriguez and seconded by MP Morrison. Meeting is now adjourned. Thank you.